the court, in listening to you, does believe that you would need a forensic evaluation.
No, I'm perfectly fine, Mr.
sir?
Simpson.
So, Mr. Warren, please state your name, sir.
My name is Joshua William Mora. I'm representing myself in this case.
So you don't want to be represented by an attorney?
No.
All right. Well, I would say there come some perils with you representing yourself. You understand that, sir?
No. I know
You
the
don't
mission.
understand?
I'm a jailhouse lawyer.
Pardon?
Right away, you can tell this hearing is taking an unusual turn. The judge is trying to establish the basics, legal representation and courtroom procedure, but the defendant is steering the conversation into conspiracy claims. That's a major red flag because judges have to determine whether a defendant truly understands the proceedings before moving forward.
What I'm doing. You are working.
I'm sorry?
You are being paid by Adolf Mack to fry me. This is conspiracy for murder. Your wife, Delphia Simpson, came up here pretending to be Ann Arbor Comprehensive Care Center yesterday. You are originally the Tux family. You are an Egyptian lord. You're Illuminati. If you do not help me,
I'm Illuminati?
I will sue you and criminally prosecute to the fullest extent.
Okay, I welcome that. You're invited
Thank
to
you,
do so.
Cedric Simpson.
What do you want to do with your case today?
Ellen Wara, Adolf Mack, Jeffrey Peak, Cynthia Miller, Frank Stanton tried to set me up, along with Derek Miller and Ryan Miller.
Okay,
They're
but
the
I've got to
Ku
do
Klux
something. I've got to
Klans.
do something. I've got to
With
do
the
something with your
NDOC.
case.
Huh?
I've got to do something with your case. What do you want me to do?
I would like to sue, and what am I in court for today? And I would like to prosecute to the fullest extent.
Okay, so
And
let
I
me
can
do
sue
this.
for
If
10 times the
they-
amount of what was stolen from me. They stole $666.8 million from me. They then turned it into $5.5 trillion and then put a hit out on me. I legally can sue for 10 times that amount, which would be $550 trillion. And I can
Okay.
criminally prosecute to the fullest
I'm with you.
extent, which is
I'm
my
with you.
right.
I did the math too. Listen, here's the thing.
Mhm.
I have to advise you, because if you are going to represent yourself, what you're here on, okay?
I'm doing it over Zoom. 'Cause they're
So
trying
you're
to kill
here
me.
on a complaint that alleges that on October 15, 2025 on South Main Street
The Pentagon's
in the
using
city of
prisms
Ann
to
Arbor,
make,
Washington
Zoom,
County,
mess up.
that you failed to stop at the scene of an accident regarding resulting in serious impairment or death. Do you understand that charge?
$1 trillion.
Yeah, sure. And that's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs.
Which is actually 10 times the amount because I can sue because it's conspiracy to murder, and sovereign law would make it 100 times the amount. But since it is conspiracy
Okay.
to murder, sovereign law
I'm with
does
you.
not
I
exist.
got you. I just have to let you know what you're charged with.
I can sue for
There's
1,000
also a
times the
count 2
amount.
on the complaint that alleges that on that same date and at that same time, that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yes.
Okay. So there are serious perils representing yourself as opposed to having counsel. I would just have to advise you, you'd be treated the same. You are charged with making sure that you have an understanding and that you abide by the Michigan rules of that you abide by the rules of evidence and the rules of procedure. You understand that?
Yes, Cedric Simpson.
All right. And the other thing that I have to advise you of is that at any point during these proceedings, you wish to have counsel.
No, I do not want any counsel, and I want a bench trial, not a jury trial. Because a bench trial is
if at
based
any point you do,
on objective evidence.
if at any point you do want counsel, you just have to let the court know, and the court will make sure that you have counsel.
No,
You
I do not
understand
want
that?
counsel.
Okay. So, what do you want me to do with your case today?
I would
now
like
that
to
I've
do a
gotten through
bench
that
trial
part.
because a bench trial is on subjective
bench
evidence,
trial?
and a jury
Well,
trial
that's
can
not
be
gonna happen.
bribed. and they're trying to
Okay, you can go to circuit court and have a bench trial.
With sovereign law, and it's conspiracy to murder, and Donald Trump and Elon Musk are involved, and I can sue for 1,000 times the amount. And sovereignty does not exist because the amount of money that
I don't know. I've not been very good at it, but
Donald Trump and Elon Musk and Adolf Mack and Doug Minkoff and Jeffrey Peake and Ellen Wara all have estates and residencies in states that do apply the death penalty. I would like to get
Okay, I'm with you. I got you. Let me hear from somebody else real quick.
If I was working with Mr. LeBeau on this file, I was going to be asking for an adjournment as this is a new file. The defendant is on surveillance video at the intersection of this crash causing this accident and then fleeing the scene. That has not been provided to either the defendant or his attorney if he has one. So we would need more time. The defendant's on parole, and if he's entertaining the idea of representing.
This is the moment everything changes. Instead of focusing only on the criminal charges, the court starts questioning whether the defendant is mentally competent to represent himself. Competency isn't about intelligence. It's about whether someone can understand the case and meaningfully assist in their own defense.
Himself, I think it's important that we refer him first.
Well, I don't know that I can do that right this second, although maybe. But here's what I'm going to do, sir.
Something.
I'm gonna adjourn your case out.
On jury trial, you cannot adjourn this. This is a high-profile case. Where I can't. Yeah.
Okay, but you haven't
too many people involved. You have a Neuralink in your brain, and you are being manipulated and bribed and conspired against for murder by the Nazis. You will work with me.
Right. So.
Here.
So you don't want an adjournment?
No, I do not want an adjournment. I want a bench trial.
Okay, so
listen, factual evidence. The jury trial.
I hear you. So the only thing that can happen is I can set this for a preliminary examination, but you haven't seen all the evidence.
I don't need all the evidence. I know all the evidence. Let me get a discovery packet though, so I can represent myself though, please. With all evidence, I would like to see.
You want to represent yourself?
And all evidence.
All right, listen. Okay.
I would like to subpoena Bill
preliminary examination.
I would like to subpoena Bill Wara. I would like to subpoena Scott Casey, the Michigan militia, all of their phones, Doug Minkoff, Jeffrey Peake, Adolf Mack, Donald Trump,
we're not bringing out
Elon Musk. Yeah,
okay. If you want to subpoena them, then you can. But I'm not bringing all those folks. My problem is he's asked for his exam. So I will have to set it. I wonder who'd like to hear this.
Your Honor, will we still be on the case?
Hang on, I'll get to that in a minute.
Thank you, Your Honor.
So, I'm going to indicate he doesn't want his discovery. Says he doesn't need it. Would they? Man. I'm not gonna have the complaint that's right. So, yes. You're gonna be mad. It's okay.
You don't care about me.
I don't care about your feelings because you don't care about mine. But you shouldn't air this in public. Yeah, I have to do the. Oh, I can't. I cannot. So I have to do it. I got you.
Okay.
I hear you, but I can't do that. So here's what I'm going to do. I'm going to set this for defendant invoking what he has. Would prosecutor have their witnesses available the 28th?
Notice how calm the judge remains despite the constant interruptions. That's not accidental. Experienced judges know that staying patient keeps the courtroom under control while creating a clear record for any future appeals or competency decisions.
Sir, I'm going to give you your preliminary examination. So your preliminary examination will be set in person on,
Your Honor, so you should
And,
just say, yes, sir.
no, I know, but I realize it's close, but,
With Carol
it-
Conkey and East Hope, et cetera, et cetera.
excuse me?
Carol Conkey is involved. She was at 22nd Judicial Circuit Court with Fryer and Ellen Warren and Jeffrey Peake. Elon Musk is with Trump at the Michigan Supreme Court in Lansing. I do not want to adjourn. I want a bench trial.
I am not adjourning. I'm giving you the quickest preliminary examination I possibly can.
Yes, sir.
But I have to hear from all sides regarding that. I would set it for the 28th. Counsel, most of these witnesses are police witnesses, so we could at least begin.
Okay, thank you. What's today?
That's a yes or no.
Yes, sir.
Thank you.
What is today, Cedric Simpson?
Pardon?
What is today, Cedric Simpson?
Today is the 23rd.
Okay, Miss Lee, I'm sorry that I'm executing your husband.
You're executing what?
Miss Lee's husband, who is Adolph Mack. I'm giving him the electric chair. And I'm suing him for everything he owns. He's JP Chase Morgan. He owns Chase Bank. I want Chase Bank. He's Hitler.
Okay. All right.
I'm suing for Chase Bank and giving JP Morgan Chase, who is Adolph Mack, the electric chair.
Okay,
If
thank
Elon
you.
Musk works with me.
Okay, so here's what I'm going to do.
And Donald Trump.
I don't know that we'll be able to go given how you're
Yes,
acting.
we will.
but
I want
I'm
a
going to
bench
set
trial
your
today.
preliminary examination.
I am sorry, Cedric Simpson, that the and Adolph Mack, JP Morgan.
I'm going to set your preliminary examination for October 28th, 2025, 9 a.m. That will be before me. I'm not, if I let the PD off, because I may, on my own motion, be referring for competency, I will do it that day. But so right now, to answer your question, Mr. LeBeau, you are still on the case. Because I think the more the merrier.
Thank you, Your Honor.
You're welcome. No, you're not really thanking me, but I get it. All right, thank you. Thank you, sir. Court does call the case, People versus Joshua Wara.
Trevor Mabel for the people here.
We are ready in this matter. Warren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Wara. Mr. Wara, state your name for the record.
Joshua.
Now we're seeing the consequences of the earlier hearing. Even after being given another opportunity, the same unusual claims continue. At this point, the court isn't debating whether those claims are true. It's evaluating whether the defendant can participate in the legal process in a rational way.
Wara.
All right. And this is the date and time I had set preliminary examination in this matter. My understanding is you would like a forensic evaluation.
That is correct, Your Honor. Based on my conversations with Mr. Wara,
Forensic evaluation for what? What's going on here?
based on my conversations with Mr. Wara, I believe that it is necessary.
Hey, I'm representing myself. What are my charges? What am I in here for? I'm representing myself. I don't need a barcode to represent myself. What am I in here for? What charges am I on here for? I don't need a forensic exam. I'm not mentally disabled. I have ADHD and PTSD. I'm perfectly fine. I'm not on Social Security.
Sir, you are before the court on a felony complaint that alleges that on or about, as I read to you before, October 15, 2025, location of South Main Street and East William Street in the city of Ann Arbor, Washington County, state of Michigan, that you did fail to stop at the scene of an accident resulting in serious impairment or death. Individual.
The guy was
That is a
perfectly fine.
felony. That is a felony, punishable by up to 5 years incarceration and a $5,000 fine plus court costs. You do understand that, sir?
I understand that. Thank you.
Count 2 on that complaint alleges that on that same date and at that same location that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yeah, I understand that.
All right. So that is what you are here for.
Mr. Simpson, I'd like to subpoena the camera footage from the mobile gas station there on North Main Street that I was at. or on South Main Street where I was at, over on South Main Street in Maynard. My car was parked there the whole time. I accidentally hit the guy. They hacked the light using an AI.
Sir, Mr. Warren, I'm gonna suggest to you this. Refrain from saying anything, because anything you say can be used.
Oh, I know. They used an AI ethical hacking app, the Tomboys and the Ku Klux Klan, and they had broken my glasses when I wasn't. They took my car for a joyride and broke my glasses while I was at St. Joe's Hospital.
The Klan did?
Huh? Yeah, the Ku Klux Klan. You can subpoena video records, and I subpoena the security guards from St. Joe's Hospital, Trinity Hospital.
That's one of the reasons, sir. That's one of the reasons why you have an attorney. Did you let them know that?
No, I don't have an attorney. I told them I don't want anybody to represent. I said I'm representing myself. Yes.
Is that what you want to do?
Yes, I would like to do that,
Sure.
and I would like to subpoena the camera footage from Global Gas Station.
Now knowing what the charges are, sir, that if you elect to represent yourself, you'll be held to the same standards as an attorney would regarding the rules of evidence and procedure in the court.
Yes, Your Honor, I
And
understand
will
that.
not be shown any favoritism.
Yes, and I would like to subpoena my discovery
If at
packet,
some point in
please.
time you wish then to be represented by counsel, you need to make that request to the court.
Okay. I
You
tried
do
calling
that.
the public defender's office, and I've tried to tell them I want to represent myself. And I've tried to subpoena my discovery packet, and they won't bring it to me. I need to subpoena my discovery packet for all cases available, please.
All
And I would like,
cases
yep,
only
and I
have
would like to
one. You have
also
more than one?
subpoena everybody's address in the MDOC that's involved in the Neuralink case through Secretary of State, phone numbers, text messages, and visual voicemail records. And I would like to subpoena the phone recordings, Securus GTL recordings from when I was in the MDOC at ARF level 4. And WCC pictures and.
Sir, I have listened to you both through the last hearing and this hearing. So what I'm
This is one of the most important moments in the entire case. The judge officially orders a forensic evaluation. Contrary to what many people believe, this isn't a punishment or a finding of guilt. It's simply a legal safeguard to ensure the defendant's constitutional rights are protected before the case moves forward.
going to do at this point is I'm not going to relieve the public defenders, but I am concerned, while you have indicated to me that you don't need a forensic evaluation, the court, in listening to you, does believe that you would need a forensic evaluation.
No, I'm
For
perfectly
your
fine,
own,
Mr.
sir,
Simpson.
sir. For your own
I'm not on Social
protection and
Security.
preservation of your rights.
I'm not on Social Security. I'm over the age of 25. I'm not mentally disabled. I do not need a forensic
And sir, here's the
investigation.
thing.
I do not
I
go
have
to the
to,
forensic center.
I have to, in terms of these proceedings, make sure that you are confident and
Well, I'm very
confident.
confident, Cedric Simpson. You can tell. I'm very
Thank you for
intelligent. I have a GED. I got a GED in 2013 in 3 months.
All right.
I got a GED from Washington Community College Adult Transitions Program in less than 90 days in 2013. You can subpoena that record. If someone can get a GED in less than 5 months, I'm pretty sure they're competent. And I would like to subpoena my GED from the Adult Transitions Program in 2013 at Washington Community College.
Subpoena. I will not relieve the public defender at this point, but I will consider certainly that once the.
Thank you. Yeah, that way, if you see I got a GED from WCC in 2013 in 3 months, you know I'm competent. You know what I'm saying? Thank you, Judge.
I am going to order a forensic evaluation. I will set a competency hearing just to make sure. I'm going to set that for January 29th, 2025.
January 29th.
a.m. I will sign an order to
Can you give me a
effect
PR
at
bond,
this
please,
time.
Judge?
Sorry?
Can I please, I would like to request a PR bond.
This time you can file a motion, or somebody can file a motion before the court, and I'll consider a written motion, but this time I'm not going to change the bond in this case.
What is the bond?
Your bond is set at $25,000 cash, sure.
Do you have any bail bondsman numbers for me that I could get a hold of, please?
Sorry,
I'd like to subpoena a bail bondsman
You
phone
can check
number.
with the individuals at the jail. I'm sure they'll be more than happy to assist you in that. All right? So that you understand, I'm leaving the public defender in the case at this point.
No, I don't want a
In the
public defender.
evaluation, I hear you, but I'm telling you what I'm doing.
And that's the key takeaway from today's hearing. The criminal case is essentially put on pause while the court answers one critical question. Is the defendant legally competent to stand trial? Until that question is resolved, every other issue, including guilt or innocence, has to wait.
We will get the evaluation. I suggest that you be cooperative in that. Maybe write it, come back competent, and we can get this proceeding moving even quicker.
Not gonna come back, huh? Y'all gonna try to.
Your Honor, before we go off the record,
Y'all for us to sit up. Y'all fucked up, people. Y'all people fucked up. Y'all.
Okay, keep moving. All right, been a pleasure.
I'm thinking of Franklin's son.
Me too.
I just want to.
Because Paris is lovely in this one.
I just want to address one thing, Your Honor, relating to the prosecutor's office's responsibility of providing discovery, and as we move forward in this case. The defendant, in attempting to represent himself in PCC on Thursday last week, stated that he didn't need an attorney, he didn't want an attorney, and that he didn't need the discovery either, that he knew what was going on, and that he wasn't worried about having all the video prior to today's hearing, and we were prepared to proceed today. At the same time, under normal circumstances, we would be in the process of getting all of that video discovery to defense counsel that he referenced wanting today. He mentioned wanting the video at the intersection. My office is in the process of getting that hopefully before the weekend. And I'm looking for permission to provide discovery to Mr. Brown's office on this file moving forward.
In response, Your Honor, as we are still on the case, I would ask that they provide discovery as they normally would.
And then if in January, depending on what happens, then certainly that information can be tendered either if he's going to represent himself, which he may be entitled to do, then the public defender can turn it over to the prosecutors we have in other cases that supply it directly to him.
Understood.
All right. Thank you.